So welcome everyone. Welcome to the third weekly tutorial in administrative law. And tonight we'll talk about merit review and administrative tribunals. So last week and in the previous week, we had essentially focused on the role of judicial review. The understanding being that, under common law, the courts had always asserted their power to be able to police the exercise by the executive of its powers. And where there was an abuse on the part of the executive of its executive powers, especially when the actions of the executive or the decisions of the executive were contrary to law, then the courts therefore asserted their supervisory power to be able to say that what the executive did was unlawful. The problem, however, is that when you look at the scope of judicial review is limited by at least two key things. One is that the focus of judicial review is to examine the legality of an administrative decision. So that is the focus. Is the administrative decision according to the law or not? So in other words, if the issue is not so much about the legality of a decision, but maybe about a factual error. And what if the scope of the factual error is really huge, it's really egregious. You know that factually it is really incorrect. The question is that subject to judicial review? So let me repeat that. So let's assume that there is an administrative decision that was made. And let's assume that the administrative decision is really wrong according to the facts. So a good example might be that if you recall, this incident of Justice Kavanaugh in the United States Supreme Court, which happened a few months ago, and there was an allegation that during his university student years, he had actually sexually assaulted a lady who is now a professor at another university. But at that time, it was actually the word of the lady versus Justice Kavanaugh, who is, at that time was already a justice of the federal court, of a U.S. Court of Appeal, and two of his friends. So it was the word of one person against the word of three. Now, let's expand that situation further so that let's assume that there's an allegation where, you've only got one person saying that sexual harassment took place, and there are 10, 12 others who say no, it never happened. And the question is, what if the court decided that to believe the victim or the accuser as opposed to an overwhelming number of witnesses? That type of situation. The question is, can that be the subject of judicial review? And the answer is no, because courts are not there as a super agency whose job is actually to make sure that there are no errors made by the executive. That's not the function of the court. The function of the court is simply to ensure that the executive acts according to the law. Now, if there happen to be factual errors in the decisions of the executive, even if that leads to unfairness, even if that leads to injustice, it is beyond the scope of judicial review. So you can see, therefore, the problem with judicial review. Okay, that's problem one. The second problem with judicial review, as we said, is that the function of the judicial review by itself is quite limited, in the sense that even assuming that the court agrees that the administrative decision is wrong, and let's assume that you have an applicant before an executive agency asking for certain benefits, and the benefits were disapproved by the executive agency because it felt that that the person was not entitled to it. And let's assume that that person therefore filed an application for judicial review. And let's assume that the court agreed that the decision of the executive was wrong. The question is, could the judiciary compel the executive to act in a particular way, and in particular to grant the benefits sought by an applicant? And the answer is no. So that is those are two things we ought to know. Now, if you look at the other practical aspects of judicial review, for those of you, you're going to become lawyers very soon, and for those of you who might have been exposed to the legal system, it is not easy being part of, being caught in the legal system. You would need lawyers. Judges ordinarily would be very unhappy if you become a self-represented litigant. You don't have a lawyer. They're not going to be happy with it. And secondly, if you need to hire a lawyer, it's going to be very expensive. It can be very time-consuming, mainly because of the rules of evidence and so on. And you have filing fees. And so what had happened, therefore, was that in 1975, or prior to that, the Australian Commonwealth Parliament decided that there has to be a better way to address, problems with administrative decision-making. Because if the only way by which citizens could have administrative decisions reviewed was to go to the courts, that represented an enormous hurdle for a lot of people. And so, therefore, that the Australian Commonwealth Parliament enacted the Administrative Appeals Tribunal Act 1975 Commonwealth. Now, if we follow, therefore, the examples I gave earlier, the advantage, therefore, of the AAT is that, one, it can correct factual errors on the part of the executive. So if there is a factual error, that is the role of the AAT. It will correct it. But it raises the question, since we know that judicial review focuses on the legality of administrative decisions, one of the questions we need to ask is it also part of the jurisdiction of the AAT to examine the legality of administrative decisions? Or would questions about the legality of administrative decisions be solely within the jurisdiction of the courts? And so, for example, if there was an application for administrative review before the AAT, and the question of legality of the administrative decision was raised, would it mean that the AAT would have to be ousted of this jurisdiction? So that's something that we need to think about, and that's something we will address this afternoon. So that's one issue. The second advantage of an application for review in the AAT or in a merits review is that, as we said, not only can the AAT set aside a decision of the executive, it can actually substitute its own decision for that of the executive. The courts cannot. The courts are powerless to substitute their own decision for that of the executive, but the AAT can, because they step in the shoes of the original decision maker. Now, there are other differences as well, but I will cover them in a short while. Now, the basic question we always need to ask is this: when does the AAT have jurisdiction in an application for administrative review? That is the basic question. So we know, for example, that, so what if, and this is crucial. So imagine if an executive decision is made, and the executive, remember, as far as the executive power is concerned, we recall, we said that there were at least three sources of executive power. One is based on the Constitution. Section 51 of the Australian Commonwealth Constitution provides for the power of the executive. And that we said, in countries such as the UK and countries such as New Zealand, they don't have any written constitution, which means, therefore, that the power of the executive must lie beyond the existence of a constitution. And we know, therefore, that in addition to the constitution, there must be certain implied powers of the executive. Otherwise, how can the executive function in the absence of a constitution? So that's a given. There are certain implied powers of the executive. There are also certain prerogative, inherent powers of the executive, which it would be crucial for the government to be able to function. And the third source of power of the executive would be what are known as statutory executive powers. In other words, there are certain powers that the executive is able to exercise as a result of a delegation of power coming from the Australian Commonwealth Parliament. Okay, so the Australian Commonwealth Parliament passes a law authorizing the executive to act in a particular way. So these are three sources. Now, we know, therefore, that as far as, and I'm going to get to the part of the merits review in a short while, just providing a background, okay? Although it's quite a lengthy introduction, I just got carried away. I'm almost done, okay? The beauty of judicial review is that if an executive decision is made, whether on the basis of a statutory authorization or on the basis of an implied power of the executive, judicial review is available. And the question we ask ourselves is this: if an executive makes an administrative decision not on the basis of an enactment or not on the basis of a statutory power, but on the basis of the exercise of implied powers of the executive or prerogative powers of the executive, is there scope for merits review? And that is a crucial point, okay? And we're going to revisit that. So today, after this session, you should be able to discuss the essential characteristics of merits review, the jurisdiction of the AAT, and the scope of AAT merits review. Now, before I continue, I'd like to listen to any of you if you happen to have any questions or any comments before we proceed. Questions, comments? We're good. Okay, now remember, my screen only shows 5 students. In fact, I only see the faces of Sarah and Lauren. I also see the names of Michael and Valentine and Nancy. Now, I cannot see the faces of the other students on my screen. I think that's a limitation of Zoom. So if you need to tell me something, you're going to have to raise your hand. You've got an icon there somewhere in Zoom, or you're going to have to unmute yourself, because otherwise, or you're going to have to say something in the chat box, because otherwise, I will not know that you wanted to say anything, okay? Because I could only see the faces of 2 students on my screen. So we're going to cover 5 discussion questions tonight, actually 6, if we include the quiz. So let's begin with discussion question 1. Can I get somebody to volunteer to read question 1 for us?
Yep, I can read it.
All right, thank you, Lauren.
Okay. The Financial Regulatory Agency, FRA, a federal regulatory agency that regulates the financial advisors industry, ruled that Mr. James Bull did not meet the professional experience requirement to be admitted as a registered financial advisor under the Financial Regulations Act, Commonwealth. Mr. Bull sought to challenge the decision in an application for review to the Administrative Appeals Tribunal. The FRA objected to the jurisdiction of the AAT on the grounds that the AAT had no power to rule on a matter that involved a legal interpretation of the Financial Regulations Act, Commonwealth. Is this objection tenable?
Okay. What do you think? Can I just get a response from all of you? Can you say yes or no? Is the objection tenable or not? So in other words, is the objection that the AAT has no power to examine, the legal has no power to do a legal interpretation of the act? Is that objection legally tenable or not? Can you just say yes or no? Okay, so from Damien, okay, very good. So no. Why is that a no? I had thought that it was for the courts to examine the legality of decisions. I'm just asking a question, okay? I'm not saying that you're wrong. I'm just asking that question. So why would it not be legally tenable to say that the AAT has no power to examine the legal interpretation of the Financial Regulations Act? Can I get a volunteer?
Yeah, I'll volunteer. I'll have a go. Sarah Rogers. Basically, it's because the AAT has jurisdiction both over fact, law, and policy, but its decisions aren't binding the same way a court would be, but they can make a pronouncement on the law. If there is a question solely upon the law, then a party can appeal a decision from the AAT to go to the federal court if it's only on the law. But there's nothing wrong with the AAT giving a decision on the legality of something.
What else could I add to that kind of answer? That's a high distinction answer. Thank you, Sarah. That's the correct answer there. So as correctly pointed out by Sarah, as far as the AAT is concerned, it has the jurisdiction to examine the correctness or it has the power to examine whether or not the decision was correct or preferable. And if it's a question of correctness of the decision, it examines both the facts and the law. Okay? And this is clearly the decision of the court in Drake versus Minister for Immigration and Ethnic Affairs. And when you look at the issue of whether or not there is a preferable decision, it looks at policies, it looks at the exercise of discretion. So that is the scope of review by the AAT, whether or not the decision is correct according to the facts and according to the law. and according to whether or not there is a preferable decision according to the exercise of discretion or policy. And so following the case of Collector of Customs New South Wales versus Breyer Lawler Automotive Proprietary Limited, the federal court also pointed out that the mere fact that there might be a legal question that is raised will not oust the administrative decision maker of his jurisdiction to make a decision. So well done, Sarah. That was a very thorough answer. So thank you. Discussion question 2. Can I get somebody to read discussion question 2 for us?
I'll go. In a case before it, the AAT considered evidence and matters that were not before the decision maker. Party X argues that the AAT went beyond its powers. Is this correct?
Mm-hmm. So imagine a situation where before the original decision maker, it could have been an application for, let's say, concerning child support. It could have been a decision for particular Centrelink benefits, and perhaps the applicant at the time failed to submit certain documents. Or it could be about, raising certain arguments before the original decision maker. And so somehow the applicant, at the time that the decision was first reviewed by the original decision maker at the administrative agency, certain evidence was not presented and certain arguments were not made. Now, all of a sudden, when that person, went up before the AAT, there were certain evidence and matters that were considered that were not before the decision maker. Would that even be allowed? So is Party X correct in saying that the AAT went beyond its powers in considering evidence and matters that were not before the original decision maker?
Wouldn't that be a de novo review, something on those lines?
Very good. So what does it mean, Darryl? Go on.
It's when they're considering other evidence and that may not have gone before to the original decision maker, and increasing the scope of the investigation.
Very good. So that's the advantage. Thank you, Darryl. So that is the advantage of having an application for review before the AAT, because you have a hearing de novo. And because it is a hearing de novo, meaning, a new hearing, and the AAT steps into the shoes of the original decision maker, the applicants are actually in a position to raise new evidence. And so therefore the AAT is in a position to examine new evidence, examine new arguments even. Courts, however, in an application for review, judicial review, do not engage in a hearing de novo. Courts are limited strictly to the evidence that has been before the original decision maker. And it's not permitted to take in new evidence. So you can see the advantage of having an application for merit review, because there is a hearing de novo. Thank you, Darryl. Questions so far? Very good. So that seems to be easy for you guys. Well done. Okay. How about this one? Discussion question 3. Can I get somebody to read discussion question 3?
I'll do it.
Thank you, Darryl.
Students protested against the visit of the Chinese Defence Minister to the Australian Parliament in February. When the student protest went out of control, student Josh MacArthur suffered injuries after he was shoved to the ground and kicked by a member of the Australian Federal Police. He filed a complaint to the Commissioner of Police against the police officer who caused his injuries. After investigation, the Commissioner of Police made a finding that the police officer involved in the incident was not at fault and decided against taking any disciplinary action against the police officer. Josh intends to have the decision of the Commissioner of Police reviewed and has come to you for advice. He wants to know if he can file an application for review to Administrative Appeals Tribunal. What would you tell him?
Very good. What do the people think? What do the students think? For Michael, equivalent to retrial. Was that the first question? Is it the second? Is it the discussion question to you, Michael? I kind of missed the time when you posted the answer there.
I'd say he would not be able to have an administration appeal
Yeah, why?
Because it'll be under Schedule 1 and that it's under the Australian Federal Police type legislation. Excuse me.
Okay.
So,
There is an important thing that we need to consider when you are confronted with a factual problem in administrative law. Try to limit, your answers to the facts that are before you. So don't examine legislation out there. So don't examine, unless I say so, do not examine, the AFP Act or whatever act is there. Let's limit ourselves to the facts here, and let's limit ourselves to the AAT Act of 1975 Commonwealth. Okay. Now, if that is the case, what would you tell? What would you tell Josh? So don't look at the Fair Work Commission Act. Just focus on the factual scenario here. Don't look at other legislation, because our focus is to look at the core principles in administrative law. Yes, Sarah?
Sorry, initially I would say it really depended upon whether there was an act or regulation or other instrument that said that the decision was able to be reviewed initially, because at the moment, based on the facts, we don't know if an appeal to the Administrative Tribunal is possible or not. So that would be my first question. Is there an enactment?
Very good. So Sarah was actually alluding to two requirements before you can say that the AAT has jurisdiction. What were those two, Sarah?
Sorry, firstly, that there'd have to be an enactment under which the AAT had jurisdiction to take a decision to the tribunal. Equally, also, I then questioned whether the decision was a reviewable decision because it was of a law enforcement nature, alluding to what Darryl was saying, because it may have been an excluded decision.
Okay, very good. So at its core, when we examine the jurisdiction, therefore, of the Administrative Appeals Tribunal, there are two things that must be there. One is that the executive decision must have been made under an enactment. So that is a crucial point. So in other words, if the executive decision is not made under an enactment, in other words, it could have been on the basis of a prerogative, the exercise of a prerogative power, or it could have been on the exercise of an implied power of the executive, such as the power to enter into a contract, automatically the AAT cannot have jurisdiction, because the decision of the AAT, number one, has to be based on an enactment. But secondly, this is the other crucial point. The executive decision, which was based on an enactment, that particular enactment itself must provide that an applicant can ask for a review of the decision with the AAT. So in other words, the jurisdiction of the Administrative Appeals Tribunal is not based on the Administrative Appeals Tribunal Act of 1975 Commonwealth. It is actually based on the enactment itself. So let me repeat. When it comes to the jurisdiction of the AAT to review particular executive decisions, its jurisdiction is not based on the AAT Act of 1975 Commonwealth, but it is actually based on the particular enactment on which the executive made its decision, and that particular enactment must provide that an applicant may apply for a review of the decision before the AAT. So those two things must be there. Are we clear? So in other words, when it comes, therefore, to the jurisdiction of the AAT, the jurisdiction of the AAT is based on, perhaps at this point, about 275 different enactments authorizing the AAT to have jurisdiction to review certain executive decisions. Now, if you compare this to the Administrative Decisions Judicial Review Act, okay, if you compare it, judicial review under the ADJR Act of 1977 Commonwealth is based on an executive decision being made under an enactment. So as far as the judicial review is concerned, under the Administrative Decisions Judicial Review Act of 1977 Commonwealth is concerned, for as long as the decision is made under an enactment, then recourse is available before the courts under the ADJR Act. On the other hand, if you wish to be able to apply for a merit review before the AAT, it is a requirement that the administrative decision must have been made under an enactment, and that particular enactment must provide for the jurisdiction of the AAT to review the administrative decision. So that is the problem there. The AAT, therefore, in a sense, has a limited scope for review of administrative decisions. If the enactment does not authorize it to review a particular administrative decisions, the AAT will not have authority to review the administrative decision. That is also a crucial point, because we know that there are certain executive agencies which were not created under an enactment. So certain agencies could have been created on the basis of the exercise of the implied powers of the executive. So the executive may create an office of whatever, strategic affairs, okay, based on the powers of the implied powers of the executive that is not based on an enactment. And let's assume that that particular executive agency makes certain executive decisions. The decisions of that executive cannot be the subject of review by the AAT, because in the first place, the decision wouldn't have been based on an enactment, but on the exercise of implied powers of the executive. Questions so far? Was that clear? Okay. There's a limited question. There's another question there, was it? Let me just check. Okay. So this is probably a good time to raise the question about quiz 2. Let's jump to quiz 2, because this is very related to discussion question 3. Yes. Can I get somebody to read quiz 2 for us? Okay, hang on. From Gary, can an enactment be amended to exclude review, or is that abuse of executive power? Can an enactment be amended to exclude review? So so we need to remember that as far as the review by the Administrative Appeals Tribunal is concerned, it is because of an authorization made by the Commonwealth Parliament. So it is the Commonwealth Parliament which passes the law, and it is therefore the Commonwealth Parliament which provides, therefore, for a review by the AAT of certain executive decisions. So if that is the case, it is also within the power, therefore, of the Commonwealth Parliament to say that the AAT has no power to review certain executive decisions. So that would be within the power of the Commonwealth Parliament itself. Okay, can I get, so the default is there is no review? Yes, so as far, that's very good, Damien, very good point. So as far as review of administrative decisions by the Administrative Appeals Tribunal, the default is that there is no power of the AAT to review an administrative decision. That's the default. Unless the decision was made under an enactment, and that particular enactment provided for review by the AAT. That's the default, okay? If you contrast that with judicial review, by default, we know there is always scope for judicial review by default. Are we clear? So by default, there is always scope for judicial review because of the common law judicial review, because we know that in the 1600s, in the battle between the UK courts and the King of the United Kingdom, the courts asserted their power to be able to police the exercise of executive power, and they won. They won that struggle. And so therefore there is common law judicial review. And so for as long as there is an executive decision, that executive decision is always subject to judicial review. Now, whether or not the judicial review will end up overturning the executive decision, that's something else, but we're talking about jurisdiction. Okay, so there is an inherent jurisdiction on the part of the courts to examine the legality of executive decisions. But as correctly pointed out by Damien, as far as the AAT is concerned, the default is that the AAT has no power to review an executive decision unless, one, the decision is made on the administrative decision is based on an enactment, and secondly, the enactment itself provided that there is that an application for review can be made to the AAT. Very good. Thanks for pointing out that out, Damien, because that's a crucial point. So in other words, even if you would have wanted for the AAT to review the decision, you're going to have to ask, does the AAT have jurisdiction or not? Okay, but the courts always will have, the power to review an executive decision for as long as you can say that there has been illegality in the decision of the executive. Okay, no more questions so far. Can we get somebody to read quiz 2 for us? Quiz 2. Can I get somebody to read quiz 2? Just to read.
All right, so the Australian Minister for Immigration and Border Protection, the Minister, terminated the employment of Visa Officer Josh Goodwin after the latter was found, after an internal disciplinary hearing, to have committed a gross error both in law and in fact in applying the Migration Act 1958, Commonwealth, to the application for an Australian permanent resident visa of Umar Uwazi Uzawi had committed domestic terrorism in Australia. The Minister used his non-statutory executive power in terminating the employment of Goodwin. Goodwin has approached you, a solicitor, for legal advice. He wants to apply for a review of the administrative decision terminating his employment. Which answer is the most correct? A, he cannot apply for error review with the AAT because the AAT has no jurisdiction to examine legal errors in administrative decisions. B, he cannot apply for a merit review with the AAT because the decision of the Minister was based on the exercise of non-statutory executive power. He can apply for a judicial review under the ADJR Act 1977 because the termination was made by the Minister on the basis of the exercise of non-statutory executive power. D, he can apply for merit review with the AAT because the decision of the Minister was based on an enactment. Or E, all are wrong.
Very good. Can I just get all of you, if you could, to try to post your answers, the letters of what you think is the correct answer in the chat box, just so we get a sense of what the class perceives to be the correct answer. Very good. Very good. So there's unanimity there. That's good. So you know the correct answer. I mean, I avoid saying what the correct answer is, but you get the gist. Let's just examine some of these answers here. A, is that correct? He cannot apply for a merit review. So you've got the answers correctly, okay? That's very good. Let's just examine the other answers here. He cannot apply for a merit review with the AAT because the AAT has no jurisdiction to examine legal errors in administrative decisions. Is that correct or not? Yes or no? Can I get a yes or no? Again on the screen, on the chat box there? No. Very good. Fantastic. So the AAT has the power to examine the legal correctness of an executive decision. Except that, as pointed out by Sarah, there is no stare decisis there. There is no precedence. Unlike in the courts where you have the stare decisis and judicial precedence, the decision in the AAT, there is no rule that every single decision of the AAT must then be followed by succeeding AAT tribunals. They can, as a matter of practice, but judicial precedence does not apply in the AAT, mainly because, unlike in the courts where the focus is really on the development of legal principles, as far as the AAT is concerned, the focus is really on the individual applicant. And because every single applicant circumstance is different, it's really difficult to say that you can talk of a binding decision that applies to all, because you're focusing not so much on legal principles, because the AAT does not formulate legal principles. It's for the courts to do that. So there is no legal precedent, as pointed out by Sarah before. Okay, so that's correct. The AAT has the power to, in fact, examine legal errors, but it is not binding. Okay, and there is no finality as far as that is concerned. So that is not any statements made by the AAT in relation to the law is not conclusive as to whether or not that is in fact the state of the law, because only the courts have the power to make a ruling on the law. Now, so we know what B is. Very good. So let's skip that. C. He can apply. What's wrong with this? He can apply for judicial review under the Administrative Decisions Judicial Review Act because the termination was made by the minister on the basis of the exercise of non-statutory executive power. What's wrong with that? Isn't that correct? Doesn't the courts have power of judicial review under the ADGR Act in relation to decisions made on the basis of non-statutory executive power? What's wrong with that? What's aha from Sarah? That's right. So both from Sarah Rogers and Sarah Goodchild, under the ADGR Act, for the courts to have the power of judicial review, the administrative decision must have been made under an enactment. Very good. So that is correct. So under the ADGR, judicial review is only available when the executive decision is made under an enactment. In other words, an act of parliament. In other words, under a statute. We've already said in the facts, where it's quite clear that the executive decision was based on a non-statutory executive power. So it's a giveaway there. We know, therefore, that you cannot have the ADGR Act as the basis for judicial review. Very good. And of course, D is wrong because it's quite clear there that the decision was not based on an enactment, but on the exercise of a non-statutory executive power. Okay. Very good. Questions so far? We're good so far? Okay. Discussion question 4. We've got 3 other questions, I think, or 2 more questions. Oh, we've got 3 more. 2 more. Okay. Discussion question 4. Can I get somebody to read discussion question 4 for us?
Yeah, I'll do it.
Thank you.
Kim Upshot operates a car rental business and has been doing most of the business accounting tasks on her own. An audit by the Australian Taxation Office revealed that Kim had misinterpreted key provisions of the Australian tax laws and as a result was deficient in the payment of taxes in the amount of $4,965. She asked the ATO to review her tax liabilities. The ATO affirmed its decision and reiterated the reasons for her tax liabilities. She was advised by the ATO, however, that the relevant laws allowed her to have the ATO decision reviewed by the Administrative Appeals Tribunal. Kim then sought legal advice to determine the next step she should take. The tax lawyer was of the view that a proper interpretation of the relevant tax laws and certain factual matters not brought to the attention before the ATO would show that Kim only owed $2,464. At the tribunal, Kim included in the statement of reasons for her application that the ATO interpretation was wrong and that it had failed to consider certain factual matters that would have caused a reduction of her tax liabilities to $2,464. The ATO argued that it was not open to Kim to raise these new matters as they had not been brought before the ATO. It argued further that the tribunal's power of review was limited to the matters and reasons cited in the ATO decision. Who is correct and why?
Mm-hmm. Is the ATO correct, or is it Kim and her lawyer who are correct? Can I get an answer in the chat box? Unless somebody wants to pick up the mic. Okay, so Kim is correct. Why is that? Why is Kim correct? What is the rule?
Operating under an enactment.
Yes. Sorry, Darren.
She has standing in the matter.
Okay.
She's operating under the enactment.
Uh-huh.
Yeah, there's a de novo. She's able to bring other stuff, further information into the review.
Mm.
And now I'll give somebody else a go.
Yeah. Keith there. Who was it earlier? Was it Daryl, I think, and Damien, who said that, at the AAT, there is a hearing de novo. So because it's a hearing de novo, that's where the applicant can introduce new evidence. So therefore, as Gary pointed out, the AAT has the power to review new material. It also has the power to review new arguments. So that's the beauty of an application for merit review with the AAT. You cannot have that in the course of an application for judicial review because it is not an appeal of an executive decision. It's simply a judicial review. If it were an appeal of a decision, ordinarily, the courts, would potentially consider new evidence. But because you do not have, when you have a judicial review, it is not really a hearing de novo that you have, but simply a question of, simply an examination of the legality of an administrative decision, and therefore, and courts do not step into the shoes of the original decision maker. New evidence cannot be presented before the court, and neither can new arguments be presented before the court. Questions so far? Clear? Very good.
Is there a point as well that the AAT is more inquisitorial in the sense it can undertake investigations itself?
Yeah.
So it's not limited to any of the information. It can actually just go beyond what's been brought up.
That's right. So, yeah, that's correct, Sarah. So that gets tricky here because the AAT is interested in arriving at a just and proper decision. I'm using a different term, and not just so it's interested in coming up with a correct or preferable decision, and it also seeks to arrive at justice in the proper case. And in doing so, it can actually seek to be inquisitorial. It can ask questions. Courts don't do that because the courts leave it to the parties to adduce evidence before it. But the AAT can have, can be inquisitorial. They can ask questions, and that can often lead to problems because to what extent should the AAT be permitted to be inquisitorial, to kind of force the parties to adduce new evidence? So but the power is there. The AAT, because it conducts a hearing de novo, it steps in the shoes of the original decision maker, as correctly pointed out by Sarah Rogers. It can be inquisitorial. It can ask questions. It can force the parties to adduce new evidence. Courts don't do that unless it is on the basis of an action on the part of the parties before the court. Okay. Now, final question. So this would be the sixth question for us. So it would appear that the principles, as far as merit review the principles are quite easy to grasp. And that's probably the reason why we only devote one chapter to merit review. Although there are some crucial points there, right? We only devote one chapter. The problematic aspects of administrative review really arises in relation to judicial review. Okay, because as we said, the problem is, there are many decisions which the executive can make, and there are so many laws, right, passed with the Commonwealth of Parliament. But how many laws are there? How many decisions are there in the executive that can be the subject of review by the AAT? So few. As of the moment, about 275 of them. So what happens to all other executive decisions that are not made under an enactment? You don't have a choice. You have to go to the courts. And that's when we have to examine questions about what are the grounds for judicial review? What exactly is the scope of judicial review remedies? So these are the issues we're going to be considering starting in week 4 all the way to week 10. But for the AAT, I think the principles are less complex. And so therefore, even the textbook only devotes, I think, about a chapter of it. And the bulk of the discussion really revolves around the complexities of judicial review. Okay, let's examine discussion question 5. And this is actually the 6th question we examined for tonight. Can I get somebody to read discussion question 5?
Yeah, righto. Angela Adams, a senior IT manager at the ATO, was fired from her job after being found to have unlawfully accessed confidential and restricted information. In terminating her contract, the ATO investigative committee was of the view she had in fact unlawfully accessed confidential and restricted info. The committee's decision was based on 1, hearsay evidence. Angela was overheard by an ATO employee releasing certain ATO information to another person on the phone, and 2, speculation going by Adams's flashy lifestyle, which could only be possible if she unlawfully sold ATO information. Adams has come to you as solicitor for legal advice. She wants to know the likelihood of the AAT overturning the ATO decision if the only evidence against her is based on hearsay and speculation. She recalls that the AAT Act 1975 states the AAT is not bound by the usual rules of evidence. Assume that AAT has jurisdiction.
What do you think?
Yeah, I mean, why not? It's if the rules of evidence, it's correct that they don't come into it, but they still need to look at things on balance and, you know, ensure that things are fair and equal and whatnot.
Okay, so there are two evidence. We've got two evidence here. We've got hearsay evidence and we have speculative evidence. Okay, hearsay evidence, for those of you who have taken up evidence, is evidence that is based on hearsay or on the basis of statements made by another person, which you've heard. So in other words, if it's hearsay evidence, the evidence is not based on your own personal knowledge. So typically, if you talk of evidence in courts, you should only be testifying as to facts or matters that are of your own personal knowledge. You cannot, you know, if you overheard somebody say something and you testify that that person made a statement, you cannot really, you don't really have any personal knowledge as to the truthfulness of the statement made by that person. So under the rules of evidence in courts, hearsay evidence is not permitted. It's not permitted. And maybe the only time when hearsay evidence would be permitted in evidence would be what is known, for example, as a dying declaration. But that's, you know, that's a special case. So let's disregard for the moment hearsay evidence. The other aspect is speculative evidence. So speculative evidence is really just evidence based on speculation. In this particular case, the assumption is because Angela was, you know, had a flashy lifestyle. She probably had a nice house, probably a nice car. She wears nice dresses. Therefore, you speculate she has a lot of money, and that money must come from the sale of confidential and restricted information. Let's focus on speculative evidence for the moment. If the question therefore is, would the AAT accept speculative evidence as evidence enough to justify a decision made by the ATO, given the fact that under the AAT Act of 1975, the AAT is not bound by the usual rules of evidence? What do you think?
I think it would. I think there's words in there that they can take information from anywhere. So I don't think that they dismiss it, but they might not really put much weight in it. So I don't think it would just be disallowed, but it might just be meaningless.
But let's assume it's just speculative evidence. Assuming that the only evidence available before the AAT, coming from the ATO decision, is simply speculative evidence. Knowing that the AAT rules allow the AAT to not be bound by the usual rules of evidence, the question is, can the AAT accept a decision solely on the basis of speculative evidence?
There must be natural justice, surely, and speculative evidence would have to weigh heavily against there being natural justice.
Very okay. Thank you, Keith. So that is correct. Essentially, because of the principles of natural justice, and we're examining natural justice later on, and I'll go back to what the principle of natural justice is in a short while. The rule has been in Re Pochi and Minister for Immigration and Ethnic Affairs, as well as in that particular decision, the federal court has said that while the AAT is actually free to disregard the formal rules of evidence, it cannot just come up with a decision without a basis in evidence having any rational probative force. So while the AAT is free to really not follow the rules of evidence, the evidence it accepts must be one with rational, it has to be based on reason, and it must have a probative value or probative force, meaning it must have the ability to prove something. So in other words, it can, relax the rules of evidence, But so in that case, speculative evidence would not be admitted. And essentially because it would violate the rules, for example, of natural justice. So as we examine later on, under the rules of natural justice, one of the key rules is that every person has the right to be heard. And what it also means is that because a person has a right to be heard, any decision made against a person must be based on evidence. It must be based on evidence that is, based on reason and that has probative value. So the AAT cannot just disregard the rules of evidence altogether. But the question is, okay, hang on, from Michael. So AAT attempts to arrive at the correct decision. So speculative evidence cannot be enough to bring a decision. That's right. Otherwise, we're back to drowning witches. That's correct. So that is correct, Michael. As correctly pointed out by Michael, imagine if decisions were made on the basis of pure speculation, right? So simply because, what if somebody has been terminated from employment in an executive agency because somebody saw that person emerging from a room, and that person was kind of dizzy or was stumbling and so on. And then you argue that that person was probably on drugs. Wouldn't that be speculation? So can you imagine if executive decisions were based on speculation? That would be dangerous. So that is not permitted. How about hearsay evidence, however? Would that be allowed? Would hearsay evidence be permitted?
Hearsay evidence, no.
Well, why not?
It says in the notes here, and I'm only just getting to that page now. Where are we? Just saw it. Hearsay evidence of non-expert opinion. They may therefore admit, for example, hearsay evidence of non-expert opinion evidence.
That's right. So because of the rule that the AT is not bound by the usual rules of evidence, hearsay evidence is in fact permitted. That's the case of Minister for Immigration and Multicultural Affairs versus Eshetu. So while speculative evidence is not permitted, hearsay evidence is allowed. So if somebody overheard something and testified that, this is what I overheard, that is permitted in administrative proceedings. And that particular case is Minister for Immigration and Multicultural Affairs versus Eshetu, because, as we said, in the AAT, they're not meant to be bound by the usual rules of evidence. Otherwise, you'll end up having lawyers, making arguments before the AAT, and it's not meant to be litigious. Okay. Very good. Questions? We've covered 6 questions so far. Any questions before we end tonight's session, or any comments? Anything you'd like to clarify? So we're good.
How could they put so much weight on hearsay evidence?
Sorry, Dara?
How could they put so much weight on hearsay evidence? I mean, it's only something they've overheard or something that somebody else said.
It's not so much that they put so much weight. It's simply a question of, are they permitted to put weight on hearsay evidence? That's really just the basic question. Are they allowed to consider, hearsay evidence and use that as a basis to arrive at a decision? And the answer is yes, because they're allowed to relax the usual rules of evidence. For as long as, when you speak of hearsay evidence, it's actually weak evidence, right? But it is in fact rational evidence. It's based on reason. There is some probative value to what you hear. You hear, you have hearsay evidence all the time. I heard my, for example, you can have gossip in the sense that you've got a friend that said, oh, I know for a fact that our boss, who is the head of the immigration department, has an affair with one staff. You heard that. That's hearsay evidence for you. If you made a testimony, that is likely to be accepted, and that's how it is with executive offices. When as far as executive agencies are concerned, oftentimes they have to rely on whatever evidence is there. Because remember, what often happens as well is that when you have an applicant, and the applicant has to, plead a particular case in order to arrive at a decision. If you were to rely on evidence that would be accepted in court, you'll have problems with the applicant because the applicant wouldn't know what evidence can in fact be adduced before it. You'll have questions saying, but that is not an original evidence, that's just a photocopy. These types of things. So if you have a non-original document because it's a photocopy, that won't be accepted before the court. But perhaps if that's the only document you have, that can still be considered by an administrative decision maker, because the administrative agencies are not meant to be acting like courts, and they're not meant to be integrating or cross-examining applicants. So that's why the usual rules of evidence are relaxed in the AAT, because the AAT is intended to be an agency of the executive. It is not a part of the court system. In other words, for as long as there is a rational probative value to the evidence that is presented, that will be acceptable. And that is following the case of Ripoche and Minister for Immigration and Ethnic Affairs. Okay, questions, comments? So we're good. Okay, so thank you very much, and I hope to see you again next week. Bye, everyone. Bye.